Hi, I'm James Minick of Minick Law. Today we're going to be talking about the consequences of underage drinking. I like to call this talk the most expensive drink of my life. We'll be talking about different consequences that result from receiving an underage drinking citation, including the criminal consequences, what happens in court, financial consequences, the cost of getting an underage drinking ticket, driving consequences, what happens to your license, time consequences, how long it takes to resolve this type of ticket, potentially get it removed off of your record, time that you spend in court, and probably the most important thing are the life consequences, which can include what it does to your criminal history, as well as potentially the impact that it would have on future employment or school. I would imagine that there's probably two people that are interested in watching this video. First of all, somebody that is doing so as a part of an underage drinking class or course, some sort of a seminar that is being presented, of which we might be a part. And then secondly, somebody that has either been charged with underage drinking or has a relative or friend that has been charged with underage drinking. And I will try to keep my topic relevant to either group that would be watching the video. I'm going to begin by talking a little bit about police techniques in prosecuting police and state techniques in prosecuting underage drinking. And really there has been an effort to ramp up police charging and investigating and actually prosecuting underage drinking citations. In North Carolina, in order to stop somebody suspected of underage drinking, a officer must have reasonable suspicion to believe that a crime has been committed. Just like any other crime, officer must have reasonable suspicion to believe that a crime has been committed. And normally in North Carolina, that is found to be present if an officer believes that somebody under legal age, under the age of 21, is either in possession of, has sold, consumed alcohol. And so that is really all that is required, and that is all that is required in order to have a person submit to a portable breathalyzer test, or a PBT. So in order to take a person's breath, the only thing that an officer would need would be the suspicion that that person is under the age of 21, which could be established by looking at a license that is indicative of somebody that is underage, or just his own personal sense impression of how old a person is. But he would need that, as well as the belief that that person has either consumed, possessed, or controlled a alcoholic beverage. There's a number of different agencies that charge these type of tickets. In the state of North Carolina, normally that's either city police, it could be campus police, it could be the sheriff's office, it could be a state highway patrolman. On a federal property, it could be a park ranger. But the most prevalent agency that has really started ramping up its individual efforts against underage drinking is Alcohol Law Enforcement, or ALE. They are throughout the state of North Carolina, and ALE a lot of times will concentrate its efforts in campus areas or areas where they believe there to be a high likelihood of underage drinking occurring, whether that's at a kind of a hot spot for this type of activity, or getting wind of some sort of a house party or a campus party. Alcohol law enforcement uses undercover surveillance, and so a lot of times they are not in uniform. They're a lot of times in street clothes as they're prosecuting and investigating these type of charges. And so again, it's a little bit more indicative of the fact that they're trying to ramp up these efforts, that they're not allowing themselves to be visible, which is one of the ways that they are really trying to crack down on underage drinking. One of the main things that all agencies are really trying to get at is the provider of alcohol for anybody that is underage. A lot of times that could be somebody that is somewhat of an innocent party, a store clerk who has been given a illegal ID or a false identification for showing age, or maybe has just mistaken somebody's age and did not ask for ID. So in some cases it is an innocent party or a somewhat innocent party, but a lot of times what they're really trying to ramp up efforts against is anybody that is purposely and intentionally providing alcohol to an underage person. And so effectively the way they do that is through a number of various police techniques, but there's been times that I've seen in cases that we've handled where very inconclusive evidence I thought originally led to a client that had provided alcohol underage, whether that was getting video surveillance tapes at a convenience store or following kind of a chain of witnesses. They are really trying to get at the person that is the provider of alcohol. And so I see a lot of times where the potentially innocent party. I've seen parents that have been charged with providing alcohol to underage persons where alcohol is being consumed in the home, and the police believe that there was no way that that alcohol could have been consumed without the knowledge of the parents, even if they didn't expressly allow or permit anybody in the house to have alcohol underage. Police have told me in our conversations there was just no way that parents didn't know about this. So there's a number of different ways that officers will look to follow that chain and figure out who is the one providing the alcohol. So that leads to the next question of who gets charged, as we're following along on the slides here. The person that gets charged can be either the person in possession of alcohol, so somebody underage that has consumed or is in possession of alcohol, or it can be the provider, somebody that is aiding and abetting an underage person obtain alcohol. Those are the main two categories that we'll be considering today. Elements of underage drinking. So now substantively, what does the state have to show? The state must prove that an underage person either purchased, possessed, or has consumed alcohol in order to establish underage drinking, as well as obviously the person's age. So they must show possession, consumption, or purchase, as well as a person being of an age less than 21. There are exceptions to the charge. These are few and far between. There's not a lot of times that we have seen this be a potential defense to a charge. Handling alcohol in the course of employment, that is okay under certain circumstances and when it does not violate other labor laws. Use of sacramental wine, obviously not a actionable offense. Use for medical purposes, so a lot of medications have some level, even if it's small level, of alcohol in the medication itself. So having talked about the elements of an underage drinking offense, let's talk about the criminal punishment for underage drinking. If a person is 19 or 20, then it is considered a Class 3 misdemeanor, and it is in fact a waivable offense to receive an underage drinking citation. A waivable offense in North Carolina means it's one that you'd not necessarily have to appear on the court date. It could be taken care of prior to court by payment. Now, I would never advise just paying an underage drinking citation, but it is something that could be handled in that manner. If somebody is less than 19, then it's considered a Class 2 offense criminally, and it's a non-waivable offense. So somebody that is less than 19, 18, 17, that person is not going to be able to take care of their ticket just by sending in a payment. They're going to actually have to go and appear at court. Under that criminal umbrella, the penalties that could be imposed for somebody that is convicted of an underage drinking charge could be a requirement to complete community service. Jail is a potential punishment, although it's pretty rare in underage drinking charges. Fines, community service fees, court costs, A judge could require somebody to be on probation for a period of time as a result of receiving an underage drinking charge. There's a lot of different things that a judge could impose as part of the criminal judgment. Could require somebody to get a alcohol assessment and complete all recommended treatment. So there's a number of different things that a judge could use to craft his judgment or sentence for an underage drinking offense. The next thing that we'll be looking at is somebody that is helping an underage person obtain alcohol, whether that's by giving them alcohol, selling it to them, somebody that is over the age of 21 helping another person that is under the age of 21 obtain alcohol is normally what you're looking at. Parents, a lot of times this can fall in that realm. It is legal to help somebody else. Aid and abet is what it is called for legal purposes. Aid and abet somebody in obtaining alcohol underage. This is punished as what is called a Class 1 misdemeanor. This is the highest class misdemeanor, and basically it is a non-waivable offense. You cannot waive your ability to go to court by paying in advance. You have to go to court for this type of charge. A lot of times we see this happen with college campus parties, whether they're on or off campus, people that are charged for basically being at the party where underage drinkers are found. Even if they haven't provided alcohol, become charged with aiding and abetting just for being present at the party, because the police don't know who it was that provided that alcohol. A lot of times nobody else wants to admit responsibility, so they just charge everybody that is at the house party. So again, you can see this in various contexts where sometimes this is charged because of an intentional act of giving an underage person alcohol. Sometimes it's through negligence, by police basically saying somebody should have known that there was underage drinking going on and had a responsibility to prevent that from happening and did not. And then sometimes it's basically being in the wrong situation, wrong place at the wrong time, being around underage drinkers that are found and basically being over age. Sometimes it's also accidental through providing somebody alcohol that you think is over the age of 21 and was not. So even people that present potentially a false ID, a clerk or grocer can be charged with aiding and abetting an underage person obtain alcohol, even if they were presented with some sort of a false ID. So if the person is underage and you provide them alcohol, whether it's selling it to them at a convenience store or giving them a drink at a bar as a bartender, passing them a drink at the party, and they tell you they're 25 and you give them a beer, it doesn't make any difference. It's all whether the person is actually underage. The punishment in this particular situation, if no jail is imposed, then a judge has to give a minimum fine ranging from $250 to $1,000, and he has to impose some level of community service, between 25 and 150 hours of community service. So it kind of depends on prior charges or lack of prior charges and other criminal sentence level, criminal history. But basically there's a lot of leeway on the part of the judge, and it's a much more serious charge than just the possession or consumption of alcohol by a person that is underage. The next thing that we're going to look at are the financial consequences, or really kind of one of the things that we again go back to as far as what this talk is called, the most expensive drink I ever had. That's what this section is about, the financial consequences of underage drinking. The minimum fines on an underage drinking related offense can be up to $1,000. The court costs at this time currently are in 2013 are $180. If community service is imposed and that's done in North Carolina, then there'll be a community service fee that's $250. Probation fees, if any type of supervised probation is required as a part of the judgment, then probation fees of a $40 installment fee and $40 monthly supervision fee would also be required to be paid. If a judge requires an alcohol assessment or treatment, or that is required per deferred prosecution program, then that can be anywhere from about $100 to about $1,500 $100 depending on the amount of treatment that is required. That is done through a third-party agency, but if that's required, then potentially you're looking at as much as $1,500 just for the assessment and treatment. If a limited driving privilege is required following a charge to get back on the road, that is normally $100 that you would pay to the clerk in the county where you're having limited driving privilege signed, and then there would be license reinstatement fees at the time that you're eligible to get your license back. An attorney fee, depending on the type of case that is brought, whether it's driving while impaired or driving after consuming under 21 or just mere possession of alcohol, aiding and abetting an underage person, depending on the circumstances and the area, attorney's fees typically range from about $500 for these type of cases all the way up to about $5,000 at the district court level. So before you go in front of a jury, you're looking at somewhere in that range depending on how the person is going to handle the case and what type of charge you're facing. To continue on in the financial consequences side of things, if the charge is ultimately dismissed, either just outright by the state or through a deferred prosecution agreement, then you would be eligible to potentially apply for an expungement. That can be as much as $180 to $200 at this time to file that expungement to the clerk's office. There can be increased insurance rates if it is an offense that causes problems with license or can be used by an insurance company to increase rates. So there can be as much as a 400% increase in insurance rates depending on the type of charge that is related to the underage drinking if there is a conviction. Drug screens can be required by a judge in sentencing, and those screens typically cost around $20 to $50 depending on where you get those. Again, those are a lot of times done by a third party, not in the clerk's office or with the court. There potentially could be civil lawsuits that come out of the situation if an underage person is driving down the road, gets in a car accident, kills somebody or hurts somebody else on the road, then either the person that is driving, the underage person, or the overage person that provided that drink or alcohol, they potentially could be civilly liable for the death or injuries of the person in the other vehicle. So civil lawsuits are very common in these type of contexts. You could potentially lose scholarships. A lot of schools, if there's a conviction of any type of offense, but certainly underage drinking, first of all, if you're expelled from school, you're obviously losing that scholarship opportunity. But even if not, even if it's just based on a conviction, a lot of times there is loss of scholarships for criminal convictions. So depending on the rules in your particular school. And then finally, loss of employment. Depending on the particular employer, either ineligibility to get certain type of employment or actual loss of your job could result from the variety of underage drinking charges that we've talked about. The next thing that we're going to talk about are the time consequences of underage drinking offense. This kind of comes through a lot of different angles as far as the amount of time it is required to take care of this type of charge. Community service, like we talked about before, is generally somewhere between 20-25 hours up to 150 hours depending on the circumstances. So that is actual real time that would be required by the court to take care of the charge. Time in court, if you have even 2 to 3 court dates, that could be 15 to 20 hours of time. And certainly if there's continuances beyond that, that's only going to add up more as far as the amount of time that you're just spending sitting around waiting for a case to be handled. And it will come as no shock that the government's not the most efficient in these type of matters, and it's something that on any given court date you could be there for 5-6 hours just waiting around for your name to be called. The time in alcohol assessment and complying with any recommended treatment, there is actual amount of hours that is normally associated with that. If somebody is required to do treatment after an alcohol assessment, the assessment itself is probably about an hour. The treatment is going to be somewhere typically between about 16 and 48 hours, depending again on the individual circumstances, but that is something that there's an actual real amount of time that is required in order to complete that. Time spent with other counselors, with people at school, if you have to go through some sort of a disciplinary proceeding, spending time with an attorney, spending time with other professionals in the area, having an ignition interlock system installed on a vehicle. All of these things, just the amount of time that it takes to drive to and from all of these places that we've talked about, sit down and work these details out. Again, a significant amount of time that is going in to taking care of this charge. And then probably the most important time consequence is the worry effect, the time that you spend just anxiously trying to figure out what's going to happen, whether that's looking actively for answers on the internet or calling friends or whatever it might be to kind of pursue the answer to those questions, or just lying awake at night thinking, how is this going to impact me? What do I need to do? Replaying the nights of the events of the night or day that the charge took place, replaying those events in real time in your head. That is a lot of time that is spent just thinking about the situation. So there's a tremendous amount of time involved in taking care of an underage drinking charge. The next consequence that we'll look at is really the driving consequence, and this very much depends on the type of charge that you're facing as far as what that consequence would look like. If it would mean a loss of license or an increase in insurance, whatever it might be, it's going to very much depend on the type of charge. But for many underage drinking convictions, including some that do not involve driving at all, you can lose your driver's license through the North Carolina Division of Motor Vehicles. Certainly if you're convicted of a DWI or driving after consuming underage, that is automatic 1-year suspension of your license or more, but a minimum of a 1-year license suspension. If you're eligible for a limited driving privilege at that time, then it will cost, again, $100 to get that limited driving privilege, and your privilege or your driving is going to be limited to driving to and from work, to and from school for what are called household purposes, which is basically a glorified term for errand running, but it's a very limited amount of driving that can occur under that privilege, and that basically does not include any type of recreational driving, whether it would be on vacation or to catch a movie, to go to a fancy restaurant. All of that would be excluded as far as the driving privilege is concerned. Again, a lot of these charges would result in increased insurance rates. For somebody convicted of a DWI, it could go up by as much as 400%, and then other lesser charges would also potentially result in increased auto insurance rates. And again, a lot of companies are careful as far as underage persons already. So anybody that is a young or new or a non-experienced driver, those are already going to be potentially high insurance rates. So when you think of multiplying that by up to 400%, it really is a big deal. And again, the way that we will approach the case typically takes into context this driving consequence, but certainly for anybody facing these type of charges, the impact it will have on your driver's license is huge. The biggest consequence that anybody is facing when they're looking at a underage drinking charge are really the life consequences of the underage drinking offense. The life consequences of getting any type of criminal offense are just really difficult to overcome, because once somebody views you as a criminal, it's really hard to get that stigma off. Again, even the most minuscule of criminal charges become a stigma on your record, on your employment. It really becomes a difficult thing to work around. And so the life consequences of the charge, again, that is probably the most serious consequence of an underage drinking charge, is the harm that it causes to your reputation. Again, appreciate you guys watching this video on the consequences of underage drinking. We have been giving this talk at local high schools and colleges. We'd be potentially interested in coming and giving this presentation live if that is a location that we can do that at. But certainly appreciate your attention, and you're welcome to contact our firm anytime regarding, again, having us come out and give a talk, or if there are particular questions about some of these consequences or a particular case, give us a call and we'd be happy to review that with you.